Go ahead and be seated, everybody. Before we start, intentions of the parties. Are more than one person going to present on behalf of the appellants?
No, Your Honor.
Okay. If I can ask the respondents, are more than one person going to present on behalf of the respondents? Okay. That societal order reigns. 30 minutes per side. How much time would you like to reserve for rebuttal?
I would like to save 6 minutes for rebuttal, Your Honor.
Okay. Now, if I can perform the functions of a 13-year-old and make this clock work right, we're in business. And we are in business. Go ahead and proceed.
Thank you. Jean-Claude Andre on behalf of Pharmacia. There's a lot at issue in this case, and while I'll endeavor to discuss some additional issues, I plan to focus this morning on the WPLA issues. With the WPLA, the legislature carefully balanced the interests of, quote, the consuming public, the product seller, the manufacturer, and the product liability insurer by including a 12-year statute of repose and limiting damages to those as recognized by the courts of the state. As the Supreme Court explained in Graybar, the WPLA creates an exclusive and preemptive remedy, and it would accomplish little if plaintiffs were able to pick and choose which provisions they would have to abide by. The trial court here permitted plaintiffs to do exactly what Graybar forbids in two critical ways: by excising the statute of repose from the WPLA and importing Missouri punitive damages in this case. I'd like to start with repose, if I may.
Okay, let me going to have a question or two about that.
Sure.
And as a starting point, so everybody understands, everybody should assume three things are true: that everybody on the panel has read all the briefing, that the panel discussed this case during the course of a 3.5-hour conference yesterday, and that because of the size of the record, none of the judges should be anticipate that we've seen everything in the thousands of pages. So legal arguments, yes. What's in the briefing, yes. Anything in the record that's significant, make sure you tell us where it is, okay? My question for you then, statutes of repose can be of two types. One I will call a general statute of repose. The second I will call a specific statute of repose. No other judge that I'm aware of shares my view on this, but I think I'm going to explain what I mean. So Washington has a builders and contractors statute of repose, RCW 416, 300 through 325. It applies to any and all claims against a specified group of individuals or tradesmen, okay? It was adopted by the legislature and then superimposed over pre-existing remedies. WPLA came about differently. It would be a specific, in my view, statute of repose, applying to a specific cause of action or sets of cause of action created in the same bill or sets of bills. Why would we analyze those two things in the same way?
Well, I don't think you have to in this case. I think that the crux of the distinction you articulated, Judge Dwyer, I think is critical. If the statute of repose, or let's call it actually the repose provision because it's part of a larger statute,
right,
at least with respect to WPLA.
Right.
If the repose provision is a condition precedent to the cause of action, adheres in it, is part of it, an element of it, then it is not severable in our view for a number of reasons that I'll get to in a second. If it's collateral to the cause of action, such as the builders and contractors example you gave, or a general statute of limitations, some background principle that may operate to a class of various claims, then it would be severable. Again, this case is, I think, probably the easier one than the builders and contractors example because .060 is part of the WPLA, and we've all looked at it. It's not that big of a statute. And it creates an element that plaintiffs must satisfy in order to have a viable cause of action. And so the reasons why we think it's not severable are at least two. One, the Supreme Court in Rice twice said, not just once, but twice said, that when you apply the substantive law of a state, you also apply the substantive statute of repose. Now, again, I realize that your question to me may make Rice distinguishable in some certain contexts, but again, not here. The second reason is Restatement 6 sub 1. There, where there's a directive to apply local law in the statute, irrespective of any other principles in the restatement, you apply that local law. Here, we believe we have a very clear directive from the legislature that the local statute of repose must apply. We have the Matter of Able case from Division 3, I believe, which looked at child support schedules and applied 6 sub 1. And in that case, even though the claimants had moved from Montana to Washington, the court said, well, that child support schedule says that Washington schedule shall apply, and therefore 6 sub 1 requires its application regardless of any other choice of law principles. Here, our local directive is even stronger, because in the WPLA, the statute of repose says that it shall apply to any cause of action under this subchapter, meaning that if plaintiffs had decided to sue Pharmacia in Missouri and the WPLA were to apply even there or in federal court, the statute of repose would have to go with it. And so we think that's the cleanest way to establish that statute of repose has to apply in this case. And then the question becomes, I guess, what does this court or what does the trial court do with it? We think we're entitled to.
What did you ask the trial court to do with it? Because you're anticipating my next question.
Well, so we
Either what, if we agree with you, what's the remedy you get here, or what remedy did you seek in the trial court?
We sought alternative remedies, and I guess it'd be the same alternative remedies that I'd be asking at your court to order. We asked for summary judgment on it because we thought that the evidence was, irrefutable that the PCBs here were beyond their 12-year.
What was it on which you asked for summary judgment?
On the statute of repose. That the statute of repose.
On the applicability or the application?
Both. That it applied, and that based on the undisputed facts that we were entitled to summary judgment and then eventually, JMAL on it.
Were those undisputed facts reliant on the 12-year presumption or on other evidence that you submitted as to the actual useful life?
Based on the 12-year presumption and plaintiff's inability to establish that the product had a longer than 12-year useful safe life.
The 12-year presumption coupled with an absence of rebuttal evidence.
Correct. And then the alternative remedy would be that at minimum this should have been tendered to the jury, and the jury should have been able to look at whether the useful safe life was somehow longer than the 12 years, than the 12-year presumption. And so again, we think we're entitled to judgment on it, but I understand that's strong medicine. At minimum, though, the jury should have been given this question, and it wasn't in this case.
If there were a remand, it sounds like you conceded that this would be, because it's a part of the cause of action itself. There's an opinion that Justice Kennedy penned where he cited with approval a North Carolina court calling it an element.
Mm-hmm.
That would necessarily have to go, if the other elements of the offense, if the other elements of the claim would go to a jury, this would have to go to a jury too.
Unless we could get summary judgment on it on the basis of undisputed
I'm
facts.
assuming there would be some factual dispute.
Plaintiffs.
I don't know that. I'm just saying. So anything that would go to a jury never has to go to a jury if you get summary judgment on it. So, but then is it necessary to retry everything, or can there be a single issue trial for a jury to determine this, to resolve any factual issues, if there are factual issues, on the statute of repose question?
Gosh, to be honest, that's a good question that I hadn't thought about. I think
it's amazing that there's anything in all of this briefing, but I'm open to the possibility. Yeah.
No, I think it would probably have to be a retrial because the complexion of the case would be different. Again, assuming that this was tendered to the jury, we would put on evidence about how the useful safe life is 12 years or a little bit beyond that. I mean, there was some testimony in this case from Dr. Cayley, our company witness, who talked about, look, at most, the useful safe life of PCBs, even when contained, is 15 years. I guess plaintiffs may come back and say, well, but, we found PCB capacitors and MSD 40 years after Monsanto stopped making them. And so maybe that's, a dispute. But that evidence would come in, and I think that would affect.
But a jury would determine that.
Correct.
Right? I mean, it's set up to be a factual question by the language of the provision itself.
Right.
If the jury determined it one way, then it would not be a barter recovery, and the decisions have already been made by another jury. If the jury determined it in your favor, it would be a barter recovery, and nothing else would need be decided.
Thinking about this a little bit more here on the fly, admittedly, I think plaintiffs have a footnote in their brief where they say that they basically reserve the right to argue that this should go to a jury, and that they should be able to put on evidence that we intentionally misrepresented facts about the efficacy and safety of the product. And certainly, if we had a limited retrial on repose, and that evidence were to come in, and the jury were to reject that evidence, then I think you'd have inconsistent verdicts or something pretty close to that. And so that's a reason why, again, just speaking extemporaneously, why I think it would have to be a full remand for a full retrial.
In conjunction with that asserted reservation of rights, a phrase that always gets my attention in terms of evaluating the efficacy of such a reservation, was there an offer of proof? What would be proved? later on. The witnesses aren't here, but this is what we're going to show.
I don't mean, my apologies, I don't recall seeing an offer of proof on that. There very well may have been. I don't want to misspeak and overstate something. But certainly they had to have a footnote in their brief, referencing this exception to .060 and the presumptive 12-year useful safe life, and they've asked for a retrial on that if we don't get judgment. And so to answer your initial question again, if this does go back for a retrial, I think it needs to be a full retrial so that we don't have this potential of inconsistent jury findings.
Well, when you say inconsistent jury findings, I mean, the jury at this trial wasn't asked the specific question regarding safe life use, correct?
That's correct. But with respect to misrepresenting facts about the product, plaintiffs certainly tried to introduce some evidence in the original trial to say.
Right, but if there was a remand and there was a trial specifically to any disputed facts as to this question, then couldn't we consider the results of that and its application to what happened with the trial that had already occurred? Why would that be inconsistent?
Because I think, at least under plaintiff's characterization, they believe that they have already proven to the jury in the trial that already occurred that there were misrepresentations about the facts and the safety of this product. And if we do a remand for a limited retrial on repose, then those facts are going to be put before a different jury.
But without the actual findings by the jury on what they found, even if evidence was represented, we don't know because they're not asked to make the determination at the end to this question.
No, right. But I guess my point is that I don't know what this court would do if you had plaintiffs construing the first jury verdict as coming really close to resolving this question in .060B sub 2, and then you had a second jury rejecting .060B sub 2. I mean, again, this is something that we hadn't thought about, hadn't briefed, but it seems really complicated and messy to me, and it seems to militate in favor of full
I think
retrial.
that we compare the verdicts because that's what we know what juries do.
True.
And if there's no indication of an inconsistency from verdicts, in other words, if there weren't interrogatories to the first jury and there was to the second, there would be no inconsistency.
True.
But that's just me thinking extemporaneously.
No, understood. Given the clarity of our 6 sub 1 argument and the kind of anti-severability of the statute of repose, I don't think this court needs to get into 6 sub 2 and looking at the various factors, but if this court were to look at them, I think the strongest evidence, or it's two pieces of particularly strong evidence. One is when you look at the interests of the other state, in this case Missouri, with respect to 6 sub 2 sub C, Grosshardt, an opinion from the Missouri Court of Appeals just 2 years ago, refused to apply Missouri's lack of statute of repose to a Missouri defendant where there were Kansas claims. In other words, Missouri refused to export its lack of statute of repose to Kansas claims with a home state defendant. And for the same reason that Missouri refused to do that, I think this court should not import Missouri's statute of repose as a policy matter into the WPLA. Again, this is all related to 6 sub 2.
It appears there's no case that has ever divided a WPLA claim from its statute of repose.
That is absolutely correct, Your Honor.
And the significance of that is what?
Well, there's two significances, if I may. One, I think if you're referring to Martin and Zaneta, the 6 sub 1 argument just wasn't made in those cases, right? And there's longstanding law, I think, in every jurisdiction, but certainly in this jurisdiction, the kind of potential issues lurking behind judicial opinions aren't holdings and don't create precedent. And so I think, to the extent that Martin and Zaneta are relevant, they're relevant only on 6 sub 2. But what is telling is that in the application of 6 sub 2, in both of those cases, the substantive law and the statutes of repose stayed with the substantive law. And so if this court were to embrace plaintiff's position, this would in fact be the first opinion to sever off a statute of repose from the substantive claims. And so that would at minimum, make some waves, but also for the reasons I'm explaining, I think would be legally wrong. And the other factor that I was going to mention that's particularly compelling if you're going down the 6 sub 2 analysis is that the WPLA was modeled after the Model Uniform Product Liability Act. That also has a repose 12-year useful safe life provision. And so to the extent that one of the factors is to look at the overall policies of the body of law within which these claims rest, which is product liability law, the Model Act looks just like the WPLA. And so if you're not going to sever off from the Model Act, the statute of repose, you shouldn't do so here as well.
So your position would be that we should not undertake that same analysis that the other courts did in Martin and Zeneda, and we don't even get there?
Right, that you don't get there. I mean, you could in the alternative if you want to, or I guess if you disagree with my 6 sub 1 argument, then you'd have to. But yes, our position is that 6 sub 1, matter of able, the restatement, they're all clear, you don't get there, and so then it tees up the question of remedy that Judge Dwyer asked me about.
Would it be different if this were a kind of statute of repose that had just a clear time limitation? Because there are sort of different flavors of statutes of repose, and some look more like statutes of limitation.
I don't think so, because the critical, and it's funny you mentioned that, reading the scholarship, there's some scholarship talking about how, I guess when I was literally a baby decades ago, that courts used to confuse statute of limitations and statutes of repose, and that only, in the last couple of decades have they come to kind of crystallize the distinction. Right? A statute of limitations puts a limit on when a claim may be brought after the claim accrues, whereas a statute of repose, whether it has exceptions like the WPLA, potential exceptions, or whether it is just a flat out, 8-year repose, 12-year repose, you can pick the number you want, that a statute of repose is a condition precedent to a cause of action being brought or extinguishes the claim regardless of when it accrues. So I don't think that the presence of the exceptions here in .060 sub B matter for purposes of your analysis, because it is clearly a statute of repose, not a statute of limitations. Seeing that my time is moving by quickly, I guess I wanted to quickly pivot to 2 of plaintiff's critical experts, industrial hygienist Kevin Coughlin and neuropsychologist Richard Perillo. To this, we made a strong showing in the trial court that both of these experts were applying novel methodologies not generally accepted in the scientific community. We weren't challenging their theory. We weren't challenging their conclusions. We weren't asserting laboratory error or nitpicking, a detail, such as in all the DNA cases the plaintiffs have relied on. To this day, because this is a burden-shifting regime, plaintiffs have still not come forward with any evidence as to how what Coughlin and what Perillo did was generally accepted in their relevant communities.
So Coughlin's conclusions were given effect by the testimony of a toxicologist.
I'm not sure I agree with that, Your Honor.
That's what the doctor testified to. He relied on Coughlin's data.
Oh, my apologies. So the toxicologist was Dr. DeGrandchamp. Dr. Dahlgren was the specific causation expert.
Okay, yeah. But what is the relevant scientific community?
Well, the relevant
The community of the person who testifies as to what it means and what they would rely on, or the community of the people who would gather the data but not testify beyond to medical causation or other questions?
I think it could be both. I mean,
Can it be either? Because if it's either, it seems it comes in.
Well, I guess.
I mean, if it's not both, but it's either, is what I'm saying. It could come in, is what I'm saying.
I guess I'd have to disagree with that too, because I mean, our position here is, again, it's not one relating to the conclusions. We are making a Lake Chelan a Moore challenge, where, at least with respect to Coughlin.
I was on Lake Chelan. There's a whole lot different from Lake Chelan.
I don't think it is. I mean, so what Lake Chelan, at least as I read it, said was that there you're applying a methodology to a new context and doing it in reverse, and that hasn't been established in the literature. It hasn't been tested by others, and therefore it's novel. And it
But toxicologists routinely take a known quantity and using mathematics trying to establish a level or range of levels at a different point in time. Medical examiners, people from the state toxicologists who testify as to blood alcohol content. Range of things where that method is employed.
So Coughlin was opining on the airborne PCB concentration at the school years earlier when the plaintiffs were present. It's Dr. DeGrandchamp who was talking about dose and what dose could cause, potential harms, and how the mechanics of PCBs. And then Dahlgren testified, well, based on Coughlin's estimates and what I know about medicine, I think these PCBs cause these injuries. Focusing back to Coughlin, there is no literature that supports what Coughlin did here. Coughlin admitted, so I'll take a step back how we got here. I think we got here because plaintiffs' counsel walked into the trial court and they said, we have Coughlin who's applying this GWO EPA study. That's a settled methodology. And we have Perillo, who's applying the Tope-Wechsler methodology. That's a settled methodology. And then once the experts actually got under scrutiny, it became clear they were not applying either methodology. Focusing back on Coghlan, the EPA study was a one-directional study measuring PCB deposition on a building material under numerous controls where the only thing unknown was the rate at which, or was the concentration of PCBs that would be left in this carpet sample. The purpose, again, was kind of moving forward. Coghlan was doing something entirely different. This is why I think it's like Lake Chelan. Coghlan was trying to back calculate what the PCBs in the air must have been years earlier, and a number of variables are not known. You don't have controlled air, you don't have controlled temperature, you don't have controlled humidity, and you don't even know the source of the PCBs. And so with all these unknown variables, you can't just reverse Guo, and Guo in fact warned that trying to apply their methodology to the real world is fraught with peril. And it's fraught with peril because in their experiment, they had all these controls and it was one directional. Coghlan not only applied it to the real world, he tried to apply it in reverse without any of the controls, and it's never been done before. He admitted repeatedly, this has never been done by anyone anywhere in the world before. And so regardless of how we construe the relevant scientific community, if no one else has ever done what he did bespoke for this litigation, then that's a novel methodology that shouldn't have come in. I know I'm running out of time here. Perillo, while not necessarily a more Lake Chelan problem, is very similar because, again, plaintiff said he's applying the Tope-Wechsler methodology. Distilled to its essence, because I know we've given you, a lot of, down-in-the-weeds science in our briefing. On a high level, there are 4 things that a neuropsychologist has to do when trying to diagnose a brain injury. You administer a reading test. You then take the reading test results and generate predicted scores in 4 different domains from an algorithm. Then you apply the Wechsler tests, which are co-normed to each of those domains and co-normed to the Tope. And then you compare the results to see whether there's a decline based on the Wechsler tests and the predicted levels. Perillo did only step 1. He admitted he only did step 1, and that what he actually did was substitute. He didn't use the algorithm-generated numbers, so he didn't do step 2. He didn't use Wechsler co-norm tests for step 3. He used a bunch of other tests that he made up, and then he made composites of those. On a general level, composites are okay, but you're supposed to, when you're doing the Tope, when you're doing the Wechsler, and you have the manual in the exhibits, it's Defense Exhibit 23752, you need to compare the Wechsler endorsed composites to the predicted scores from the Tope algorithm. Perillo didn't do that either. So when 75% of what he's doing is not applying the settled methodology, that is a new methodology. And again, like Coghlan, he admitted that there's no literature supporting what he did, and no one else has tested it. And in fact, no one else can test it because he hasn't disclosed his methodologies.
And all of those things were subject to attack on cross and through your other experts, right?
They were, but when an expert walks in with the kind of imprimatur of being an expert and is talking about complicated things, that's why we have a gatekeeper judge to ensure that only legitimate science that's been tested in the scientific community as opposed to in the court, in this case, comes before the jury.
Can we go back to Coghlan for a second? Because the Fry inquiry is critical, right? And we are to look at that de novo. So my question to you is, what is it that we are looking to determine whether it is novel? We've got him saying that you can do this. We've got a lot of information about source sync dynamics. That's acceptable. And then we've got other experts who've basically been paid to say, no, that's not. Is it just a matter of who has got experts to tell us that? Are we supposed to do independent research to determine that?
Well, I mean, you can do independent research if you're so inclined. You can look at the Guo paper and the warning that the Guo authors gave about trying to do what Coghlan did, and you can also look at Coghlan's own admissions. So even if we didn't have our own experts to disagree with Coghlan, you can look at Coghlan's own admissions that no one else ever in the world has ever done this, that the EPA would not accept the carpet sample that he used, and based on just those 3 simple facts, each one of them, I think, independently establishes that these things are novel.
But it's not exactly that simple. I mean, the Fry test allows for Galileo, but not for Joe Rogan.
Right.
And so the question is, who is Coghlan closer to? And I know you have an opinion, but that seems to me our task. Is if he's first, it doesn't automatically make him wrong, but it does mean that you look much closer.
Right.
Okay.
I see that,
You can summarize.
well, I guess I wanted to touch on punitive damages, but that would eat into my rebuttal time.
Yeah.
Is that my My choice?
It's your choice, and
Sure, I guess I'll eat into my rebuttal time a little bit if I may.
if you want to eat 1 minute into your rebuttal time, how much do you want to eat?
One, yes, I'll eat it
Just
for one.
inquiring as to your appetite.
Thank you. So like with repose, here the WPLA and Gray Bar reinforces this. It's an exclusive preemptive remedy, and the WPLA provides that damages are the damages only recognized by the courts of this state. When the WPLA was enacted, this state had never imported into a product's case punitive damages. And so that provision, I think, tells us that the only damages that are available in a product's case are compensatory damages. And of course, this is part of the greater balance too. This state has effectively limitless or standardless punitive damages, which can result in very high compensatory damage awards, like the ones we saw in this case. And against that backdrop, it's particularly, I guess, telling then why the state would forswear punitive damages.
So if we disagree with you and go on to do that analysis and determine it can be severed, right, or that we look at punitives separately, do we look at Washington's general policy about punitives? Is that appropriate? Is that an expression of our state's interest?
You can answer that question.
I think you start by looking at the general Washington interest. I think you look at it through the lens of this compromise of potentially higher compensatory damages and no punitive damages. And then as you go through the other 6 sub-2 factors, you have to look at Missouri's interests. Missouri's interests are not to have freewheeling, unlimited punitive damages without any procedural safeguards. You can look at the overarching goals of the regime. And you look also at plaintiff's choice. Plaintiffs chose to sue in Washington. They chose to sue under the WPLA. And when you add all those factors together, I think this case comes out differently than Singh, which was a 6 sub-2 case. And also, if you look at Barr from the Supreme Court, it kind of compels what we're urging here, which is that you look at the most immediate harm-causing conduct, and here that conduct, through the lens of 6 sub-2, would not have been in Missouri. It would have been in Washington.
At this point, I declare you sated. In 30 minutes, we'll see you back again.
Good morning, Your Honors. Deepak Gupta for the plaintiffs. I'd like to jump right back into the seminar on choice of law, but if I may, I'll just take a minute on the big picture, but please jump in because I know you've thought a lot about this. 2 years ago in Coogan versus Borg-Warner, the Washington Supreme Court underscored the importance of the civil jury in this state's constitutional scheme, and it emphasized what it called the compounding layers of deference afforded to a jury's verdict on appeal. That deference is surely warranted here. This landmark verdict against Monsanto was the culmination of an extraordinarily thorough, hotly contested litigation process. Years of probing discovery with 142 depositions led to a trial with 46 witnesses and 15 experts. Before, during, and after the 7-week trial, Monsanto left no stone unturned, challenging nearly every facet of our case, crossing all of the experts. All told, the King County Superior Court ruled on 115 separate pretrial motions. Judge Richardson and then Judge North each took a fresh and careful look at the issues. Monsanto now spends hundreds of pages attempting to retry this case on appeal, fly-specking evidentiary decisions made by judges who heard not hours, not days, but weeks' worth of arguments. As Judge North recognized below, the verdict is supported by not just substantial, but overwhelming evidence. We know, and Monsanto does not deny, that the teacher's brain damage is real. We know, and Monsanto does not deny, that PCBs were in the air, the carpets, the soil, the light fixtures, and the caulking at the school in Monroe during the years that the teachers spent every day working there. The jury heard firsthand testimonies of PCBs literally dripping from the ceiling during that time. We know, and Monsanto does not deny, these PCBs came from Monsanto because it was the exclusive maker of PCBs for 4 decades, until they were banned by every nation in the world. We know that lower chlorinated PCBs, like those at the school, harm the brain directly in numerous ways. We know that multiple qualified experts, including experts Monsanto doesn't challenge today, identified PCB exposure as the cause of the plaintiff's injuries. And we know that other potential causes were ruled out through repeated testing. Finally, we know that Monsanto was well aware for decades that PCBs were highly toxic for humans. And as Judge North put it in his post-trial order, the evidence at trial established that Monsanto for decades engaged in a corporate disinformation campaign to undermine the evidence of dangers of PCBs. Now, Monsanto's lead argument on appeal is that the jury verdict should be thrown out because the trial court erred with respect to choice of law. And they can seem like thorny choice of law questions in the briefing, but I actually think they are controlled by precedent. And I want to start, if I may, with the Washington precedent on this, but I do want you to jump in.
What I'd like to do is give you an opportunity to answer one of the first questions I asked counsel. You heard my description of what I characterize as a general statute of repose as against a specific statute of repose.
Right.
So my question is, do we in fact review the application of, or applicability of these two different types of statutes of repose in the same way? And if not, in what way does our review differ?
Right. I don't think it differs. I mean, I think first of all, I would say the Washington statute of repose, and it's not different from statutes in other states, makes this repose question a defense. And you know that because it says that the defendant establishes it by preponderance of the evidence. So it's not part of the case in chief. The plaintiff would present their case, and then the defendant would elect whether to raise the repose question as a defense, and that's classic affirmative defense language when the burden is placed on the defendant to raise the issue. I would also say that Washington is not the only state in the country with a products liability statute. Virtually all of the states in the country have products liability statutes, and they share most of their features in common with one another. And it's also not the only statute with a statute of repose. And so I think I heard my colleague tell you that they weren't able to identify for you a case that stands for the proposition that they're advancing today, which is that you can't do choice of law analysis separately.
Well, what you heard was an answer to my question, which was, has there been a Washington case that resulted in that which you advocate, which is a severing of, in a specific statute of repose situation, a severing from the statute of repose from the creation and establishment of the underlying causes of action.
Right. There is no case. I mean, if there were, we wouldn't be having this discussion probably. But I do think that it is the implication of the analysis in cases like Zenaida Garcia and Rice. And maybe we should start with Rice because my friend places.
Well, let's start with this. I don't know if troubled is the right word, concerned by the presentations of the parties, which treats conflict of laws as more important than constitutional law. And what we have here is an action by the body, the legislature, that our state constitution says all legislative authority is granted to and established in the legislature. And we're asked to arrive at a conclusion that appears to be different from that arrived at by the legislature as a clear result of compromise. 1981, new Republican governor replaced a Democrat. Republicans controlled the House. The start of the session, it was Democrat-controlled. One senator switched parties, it became Republican-controlled, and there emerged the Tort Reform Act of 1981. Reality plays a part in things.
Right.
If we were being asked to opine on the constitutionality of this section, one of the things we would be asked or tasked with is determining, in the absence of 060, is there evidence that the legislature would have passed this bill?
Right.
Okay? Why don't I ask the same thing here?
Yeah, let me try to help you with that. And I have to admit, when I first came to this case, I hadn't done a lot of choice of law, and it's not a body of law that we deal with every day. But one of the foundations of choice of law is that it is common law. So it is the backdrop against which the legislature acts. And the legislature passed the statute in 1981. The Washington Supreme Court had just decided Johnson versus Spider staging, and it adopted the restatement second in this very context for product liability. And it did issue by issue analysis. and it declined to apply a statute that would have immunized the defendant's conduct, a damages cap, on a very similar rationale. It's the rationale that's adopted in Zenaida Garcia and in Singh. And so the legislature is understood to act against the backdrop of that statute. It's part of the architecture of the state's law. And the legislature, of course, can override that common law. It can, of course, say, we don't want to follow the background choice of law rules. And Washington's legislature has done that in some cases. It's done that when it adopted the Uniform Conflict of Law.
Did it seek to do that by using language akin to no person shall be liable under this chapter unless?
No, and here's why. Because statutes always contain mandatory commands. They always use shall language. But the restatement tells you the methodology, and the legislature is, again, presumed to know this. Then when it wants to speak to choice of law, it does so clearly, and it uses words like apply or govern.
Speak to the preamble, because the preamble exists as a statement of what the legislature was attempting to accomplish.
Right.
Now, you treat the preamble in your briefing as establishing that this is a consumer-friendly set of statutes or bill. The legislature doesn't take that approach. It
Right.
says it considered the consuming public, product manufacturers, product sellers, and product liability insurers, and is in this creation attempting to enact a balance
Right.
of the concerns. And it seems that what happens here, or what happened here, is that that balance was upset by removing one of those things that benefited product manufacturers, product sellers, and product liability insurers.
Right.
And so if I believe that that affected the balance, what do I still have to believe in order to rule in your favor?
Sure, yeah, let me try to help you with this. I would say, first of all, that part of what you're saying is part of the critique of depassage. So the Indiana Supreme Court has kind of gone on its own on this, and there's a case, Simon versus United States, that may be worth taking a look at. And that's their critique. They say, we're not going to do depassage because a statute is a package, and the legislature, does it as a package, and so we won't address separate issues separately. That is not the restatement second approach. It's not the Washington approach. It's not the approach followed by the majority of courts. And again, I mentioned earlier, Washington.
But most bills don't have such a precise statement of seeking a balance between identified
Right.
differing
Well,
interest groups.
so Washington was not alone. If I may, I think it's just worth talking about what happens in other states, because this isn't a unique problem. It may be a unique problem for you in Washington. We haven't confronted this exact question, but it's been addressed in other states. And so we filed with the court a statement of additional authority that mentioned some of these cases, the New Jersey Supreme Court case, a case from the Fifth Circuit that was cited in our briefs, Marchesani. And I thought it might be useful to you if I just talk to you about those cases very briefly. So Georgia in 1978 passed its products liability statute. And if you look at it, Georgia's politics were similar. It was a kind of a tort reform statute, balancing the same competing objectives. Comprehensive products liability statute has a statute of repose. Tennessee, same thing. They have a products liability statute. It has a statute of repose. And so in the Gantis case in the New Jersey Supreme Court, the question was very similar to what you face here. The question was, the claim arises under the Georgia products liability statute, which has these, this competing balance. Do we apply the Georgia statute of repose? And the court there applied the same kind of analysis that this court applied in Zenaida Garcia, and said that the Georgia law governs the underlying merits of the claim, but New Jersey law, which doesn't have a statute of repose, governs and allows the claim to move forward. In Marchesani, that case was decided by the U.S. Court of Appeals for the Fifth Circuit. The case was brought under Tennessee's comprehensive product liability law, of which the repose provision is a component, just like here. And the question was, what governs the underlying claim? And the court said, we conclude that Tennessee law governs the rules for compensation and liability, but then there's a separate analysis about whether the Tennessee statute of repose has to come along with that. And the court said, no, we apply issue by issue analysis, and we conclude that Louisiana law governs the question of repose. The case moved forward. Ehrenfeld, same thing.
Did the Tennessee statute have language similar to no liability under this chapter unless?
Yes, I think I'm not sure that it's distinguishable. It's no action.
I'm not asking you to distinguish it, I'm
yeah.
just asking you to tell me what's in it.
Yeah, I mean, I think it says, something like no action is permitted under this subchapter or this chapter, whatever, the same kind of language that's at issue here. And the courts have treated these the same. They're substantive. All conflict of law analysis is about substantive law, right? That just starts the discussion. It doesn't end it. But it's commonplace to, in products cases, because products are often manufactured in one state and then injure people in another state, to do issue-by-issue analysis with respect to issues that, there's no question that when the legislature enacts a comprehensive statute, it addresses all of those issues as a question of local law. The question is, how does choice of law analysis work when the legislature hasn't overridden the background common law? And so
Should we look at the legislature? So a lot of this depends on what they chose to say in their preamble, or,
Right.
I guess I have a question about how deep do we go in the legislative history, but particularly with regard to the issues in this case, is there a difference between the absence of language on punitives? Does it matter if there was legislative history saying we are rejecting this, or do we just look at what they have there, which is an absence?
No, I think you start with all statutory questions, you start with the text. And the legislature knows how to override the background common law on choice of law when it wants to do it. And Washington has done that. It did that when it passed the Uniform Conflict of Laws Limitations Act. It speaks very, very clearly. And when it does that, it uses words like apply and govern. It's very, very clear that it's overriding that background law. And Washington didn't do that here. And so I think, you don't have to do a deep dive into the legislative history.
What year was that enacted?
That was enacted in 1983, I want to say. I might be slightly off about this, 1983 or 1984. And then the Washington Supreme Court addressed it about 10 years later in the Rice versus Dow Chemical case. And I think it is worth just spending a minute on that case, because my friend relies on it. And I actually think if you read the case correctly, it helps support what we're saying. So a central feature of Rice was distinguishing the treatment of statutes of limitations under the Uniform Conflict of Law Act and the treatment of statutes of repose, which are substantive for choice of law methodology. And the court explained that because of this Uniform Act, quote, variations in limitations periods are not subject to conflict of laws methodology. Instead, under the Uniform Conflict of Law Act, the statutes of limitations track the underlying substantive claim. So in a simple case where, somebody has forum shopped, they've come in from some other state, and they're attempting to evade the limitations period in the other state, they can't do that. And that was the main reason for adopting this Conflict of Law Uniform Act, is to prevent forum shopping. But then the court went on to explain, on the other hand, I think this is actually the main point of the Rice opinion. It's why the court spent so much time on this. Statutes of repose are to be treated not as statutes of limitations, but as part of the body of a state's substantive law in making choice of law determinations. And then the court explained that the standard framework applies, which is to determine which state's law applies to a particular issue. And this was a products liability claim. I mean, it would have been strange in a products liability claim where the first step under Section 6 of the restatement is to see whether there's a contrary statutory directive. It would have been quite strange for the Washington Supreme Court to engage in this extensive analysis. And the same thing with Zanetta Garcia. If my friend's argument was correct, that you don't do issue-by-issue analysis, that you simply figure out what is the underlying substantive claim governed by, and then repose follows that. It's completely at odds with that opinion. And then there's one sentence in the Rice opinion that I want to make sure that I talk to you all about, because it is the sentence, it is, I think, my friend's favorite sentence in their favorite case. It is the second to last sentence in the Rice opinion. Every time they quote that sentence, they do it with square brackets. That replaces the term limitations period with statute of repose. And I think that's critical, because the whole point of the opinion is that statutes of limitations and statutes of repose are treated differently. The statutes of limitations you follow what they call the borrowing statute. You just, borrow the underlying substantive law. But with statutes of repose, you do an issue-by-issue second restatement analysis. And so I think that dispenses with Rice. I think they haven't cited you a case, virtually every state has products liability laws. They haven't cited you a case that stands for the proposition that you cannot, as they put it, sever the repose period from the underlying claim. And we have cited you a bunch of cases where this issue has come up, and the courts around the country are applying conventional choice of law analysis to determine whether the repose period of a different state's law governs.
So you urge me to be of a mindset that the 1981 legislature, concerned with balance and having inserted 060 into this act, was nevertheless itself open to the fact that 060 could be read out of the statute as a result of the common law.
Not the way I would put it. I wouldn't say it's
I
reading
tried
it
to
out of the
be as
statute.
provocative as I could with
Yeah, I don't think it's reading it out of the statute. And I think that and there's a great law review. I normally cite law review articles in oral arguments, but there's a great law review article by Professor Caleb Nelson that really explains how this all works. And we cited in the brief that the background, it's often unstated, but the background is that the choice of law principles will govern because the legislature typically isn't thinking about choice of law. It's governing with respect to local law. And so for local law, as a matter of Washington law, of course, the statute of repose governs. All the features of this comprehensive scheme govern. But once you have a question of conflict of law, you're not only honoring the Washington legislature. We live in a federalist system, and the courts, this state's courts, and all of the courts in the country have to show comity to other sovereigns. And so the goal is—
do they have to show comity when they're attempting themselves to arrive at a balance with full knowledge that other states might see a different balance as being appropriate, which nevertheless would be irrelevant to the people voting on this bill?
What I would say is this, that if you want to think about the role of a judge when you are doing a choice of law analysis, yes, of course, you have to be as faithful as possible to the legislature of this state, but you also have to show comity to the other states. And where this comes in is that
But
once
nothing
you—
prevented you from filing under the products liability laws of Missouri.
I'm sorry?
Nothing prevented you to proceed under the products liability laws of Missouri here, rather than Washington.
Well, I don't know that we could have come in and done that. I think the conventional choice of law understanding is that for rules of compensation, for liability and compensation, Washington's rules would govern the rules of the place of injury. And then for rules that are what the scholars call conduct regulating rules, things like, punitive damages and repose, which are focused on the defendant, the choice of law rules dictate often that the home state of the defendant's law would govern. So I think I hope that's an answer to your question. So as I was saying, when you're doing this interest analysis, I think you do have to take into account the policies of the Washington legislature, just as you also take into account the policies of the other states' law. And the way to do that is, the whole point of choice of law analysis is to try to come to an accommodation of those competing policies. And you see the Washington Supreme Court doing that in Johnson versus Spider Staging in a product liability case. And this court did that in Zenaida Garcia and in Singh. All three are product liability cases where the product was made in one state and injured somebody in another state. And the question was, granted, setting aside the question of whether compensation and liability rules are of one state, what about the rules that focus on the defendant's conduct? How do we accommodate the competing state interests? And so you're not at sea here. You actually have a framework in Washington that has been in place for as long as I've been alive. And our submission is simply that the court should follow that precedent, that roadmap, not because it means doing anything that does violence to what the Washington legislature had in mind, but because the Washington legislature is presumed to act against the backdrop of choice of law principles. And those are, as it were, incorporated into every statute that the legislature enacts, unless the legislature says otherwise.
So if we are using the restatement and looking at this statute, I guess what I'm wondering is if we were to go down that path and look at the different interests, we're supposed to do a qualitative and quantitative analysis of the context. Would it be different if we did that analysis about the statute of repose in particular versus the liability portion of the statute?
Yes, I mean, and again, I think that, Singh and Zenaida Garcia they light the way, right? I think they're very similar cases. In both cases, you had, as I said, a product that was made in one place and injured people in another. In Singh, the claims were, you knew that there were dangers about this product, and you concealed those dangers, and you made all those decisions in your home state, in California. You had memos internally, you made decisions not to warn people, you did all that there.
And those are all about the substantive liability claim.
No, I mean, those are the whole point of issue by issue analysis, right, is you focus on the issue that generates the conflict. And so for punitive damages, there's obviously, nobody's denying there's a conflict between Washington's policy against punitive damages and California or Missouri's policy that allows it. And so you focus on the interest of the two states with respect to that question, right? And what this court said in Singh is that Washington doesn't really have any interest in precluding punitive damages in that scenario. And you asked earlier, Judge Chung, you asked my friend, what is the role that Washington's policy on that issue plays, the policy on punitive damages? I think one case to look at is Kammerer, because the dissent in the Washington Supreme Court in Kammerer was all about, we should be honoring Washington's policy against punitive damages. And the majority, I think it was a one-justice dissent, the majority overwhelmingly rejected that view and instead permitted, under a second restatement analysis, California's law on punitive damages to govern. So the analysis is really very similar to both of those cases. And I think that's why Monsanto has put so many eggs in the basket of trying to exit the conventional framework. Because if you just follow the conventional framework, as the Superior Court did here, and as several Superior Court judges have done in the subsequent cases, it's not a terribly difficult choice of law question. There are much more difficult choice of law questions where the states really have conflicting interests. What this court has said in those two cases and in Spider Staging is ultimately, when it comes down to it, while the contexts are evenly balanced, the interests are not at war with one another, because Washington doesn't have any interest in precluding the law of another state from deterring or punishing this conduct, or from precluding, from imposing repose.
Are you talking about the repose argument or the punitive damages argument?
Well, both, Your Honor. I mean, I think that
I see a difference, because Washington did declare an interest with regard to the repose period in the preamble.
Let me help you. I mean, imagine, I would make the same argument if in 1981, Washington had said in its statute, thou shalt not have punitive damages under this subchapter, right? So they had wrote the policy into the statute, as some states do, right? It would be the same exact question, because that would still be a statement about what Washington law is, right? And so you would still be asking, and I think Kammerer, this is what Kammerer is all about, and Singh as well. They assume that that's Washington's policy. The question is, does that policy apply where the conduct all occurred in a different state that would permit those damages?
You're suggesting that when the legislature adopted the WPLA, they understood there are situations where there's a conflict of law and choice of law analysis.
Exactly.
So even though that their language, what they used regarding shall is applying to what you're saying locally,
Yes.
understanding that there could be a circumstance where it involves another state and the existence of analysis under choice of law.
Exactly, Your Honor. Exactly right.
So comment B to section 6, I believe, of the restatement, talks about not broadening the applicability
Yeah.
by means of applying a conflict of law analysis. This seems very much to be, and I'm thinking of repose, but
Right.
intellectually I'll deal with the other second because I can only handle one thing at a time. But this seems to be broadening the applicability by eliminating the possibility of the cause of action not accruing.
Yeah, I think that's just not what comment B is about, and we didn't really get a chance to respond to this. I think comment B mostly came up in the reply brief, so I'm glad I get a chance now. Comment B doesn't undercut all of comment A. What comment B is about territorial, what the legislature's understanding of the territorial application of the statute was. And so it says, for example, in comment B, if the legislature intended that the statute should be applied to out-of-state facts involved, the court should apply it unless, so that's what that's about. It's about the territorial range of the statute. It's not about overriding conventional choice of law
Well,
analysis.
what's the principal distinction between a territorial range and a temporal range?
The territorial range would be, the statute would say things about where the transaction occurred, where the seller was, and this is not that uncommon, that the legislature doesn't use words like, apply or govern, but it uses words about, who is involved and where they are. And we cited you, there's not a lot of case law on this, but I think if you look at the case law on comment B, you'll see it's about territorial application. We cited you one Arizona appellate case in our brief, intermediate Arizona case that talks about this.
It was written by O'Connor, it's a home run.
Unfortunately, it's not, but I think it's a pretty good opinion. And what it says is that, this kind of clear statement rule applies. So if the legislature spoke very clearly about extraterritorial facts, obviously we should honor that. But this is not an exit from conventional choice of law analysis. And if it were, then, the choice of law jurisprudence would look very different. And, I think ultimately, you don't have to do anything very exotic here. I think all you have to do, what we would urge you to do, is to follow this court's precedents in Singh and Zenaida Garcia and the Washington Supreme Court's decision in Spider Staging. Thank you.
Thank you.
Thank you. Judge Dwyer, I know you said that you see repose and punitives differently, and I guess I would like to try to convince you to not do so.
Well, I didn't say that I concluded that they were different. I said I see what the considerations are as being different in their applications.
Correct. And I guess, again, we still think that the harm equals damages as recognized by the courts of the state as being a clear directive that punitive damages are off limits. But to pick up on some of what Mr. Gupta said with respect to, even if you, also your question, Judge Chung, if you go down the 6 sub 2 analysis, what was animating both Kammerer and Singh in their 6 sub 2 analyses was the fraud of the defendant. And we don't have whatever, plaintiffs, and giving all deference to the jury's verdict, whatever we have here, we don't have fraud by Monsanto with respect to post-sale failure to warn or Monsanto's conduct. We just have what the jury found, that we manufactured a defective and harmful product, and that it was outrageous, but not rising to the level of fraud. And so those cases are distinguishable, and so when you do balance, do the qualitative and quantitative analysis of all of the interests mentioned in 6 sub 2, we think comes out in favor of preserving Washington's tradition of having no punitive damages in light of the background principle that compensatory damages can be really high. But I do want to make one additional point, which is that even if you disagree with all of that, we don't see how the punitive damages award here can stand, given that post-sale failure to warn was one of the theories tendered by the plaintiffs that Judge North permitted the jury to hang punitive damages on. And that, is a cause of action that neither state would punish, because again, we're talking about punishment in this regime. Washington wouldn't punish it because Washington doesn't punish anything because it has no punitive damages, and Missouri clearly wouldn't punish post-sale failure to warn because it does not even recognize the claim, so it doesn't even proscribe that conduct. And given that there was an undifferentiated verdict here, where the jury was permitted to award punitives on post-sale failure to warn, even if you disagree with my arguments as to why punitives should be out of these cases, at minimum, there would have to be a vacator and remand for a new damages trial without post-sale failure to warn in the case. Getting back to repose, I think, and I'm not just trying to pander or parrot Judge Dwyer, but I think Mr. Gupta's argument that somehow the background operation of choice of law means that the legislature can't override it with WPLA just doesn't make any sense. The language is particularly strong with respect to .060, saying, there shall be no liability for any cause of action.
And is that language similar to other states' language where, in fact, they allowed the circumstance that happened here?
So the language is similar. Mr. Gupta was correct about that. But with respect to all the cases he cited, in particular the ones that were mentioned in the footnote in the supplemental authority, and he went through some of them involving Tennessee versus Louisiana, none of those cases actually involve or even address the 6(1) local directive analysis. They are, like Martin and Zaneta Garcia, and to some extent Rice, they are just 6(2) cases. So again, we think they're irrelevant because for whatever reason, and I don't know, what the defense bar was thinking in the early 2000s when these cases were decided, people weren't making the 6(1) argument, even though it seems really clear that you first look to see whether there's a local directive. So those cases, like I said, like Martin, like Zaneta Garcia, just went to 6(2) without ever saying we're not going to apply 6(1). And so they're simply uninformative, at least on the first portion of our argument, which is that you have to stop, look at 6(1), look for the legislative directive as animated by the policies embodied in the overarching legislation, which again here was all about balancing the interests of the various competing interests and not just providing a consumer remedy for Washington plaintiffs. I think with that, unless the panel has further questions, I'm happy to give back the time that I still knew
I have
earlier.
one question before you run out of time. Going back to the experts and Dr. Dahlgren, well, his testimony indicated that he considered, I don't know if I'm pronouncing the name right, is it Coughlin? Is that how you say it?
Yes, Coughlin.
Coughlin. But during the testimony, he was specifically asked, and roughly how high would it have to be to cause that kind of reaction to people? So his testimony was the symptoms that were they're shown by these teachers. And then he answered, according to the EPA, 13,000 to 260,000. Doesn't that provide evidence, circumstantial evidence, that the jury could consider without consideration of Coughlin's analysis?
No, for two reasons. One, Dahlgren admitted earlier in his testimony that he was relying
Go ahead, Finn.
exclusively on Coughlin's estimates and then applying a multiplier that we frankly don't even know where it came from. And so he said it, but the problem is that if Coughlin's estimates are improper because they don't satisfy Fry or because they're too speculative, because even then Coughlin's estimates were only that these plaintiffs may have been exposed to levels above the safe thresholds or may have been exposed below, then Dahlgren can't just piggyback on that unless he offers something additional, and he didn't here.
Okay, thank you.
Thank you.
To everybody, we appreciate your thoughts and efforts, and we understand the significance of the assignment that we receive. We're in recess.